in relation to the accused. This factor is to be considered when determining whether any conduct could reasonably be expected to cause the intimate partner to believe their safety is threatened. The purpose of this provision is to assist in minimizing opportunities for the offense to be weaponized against the victim by requiring consideration of the whole context of the offending, and in particular, any power imbalance between the accused and their intimate partner, which is generally present in relationships marked by coercive control. Situating the alleged conduct in the overall context of the relationship at issue could assist in identifying the true aggressor, including in cases involving mutual intimate partner violence allegations. Turning now to the penalty provision, proposed subsection 264.014. The proposed penalty is a maximum of 10 years on indictment, which would treat the offense the same as criminal harassment and ensure its eligibility for dangerous offender and long-term offender designations. Finally, the for greater certainty clause in proposed subsection 264.015 clarifies that safety includes psychological safety, which is the same meaning as it has in the context of the Criminal Code's criminal harassment and human trafficking provisions. I hope that assists the committee and would be happy to try to answer any of your questions. Thank you.
Thank you very much. That explanation is extremely helpful and valuable as we continue to do clause by clause, and I hope it has benefited some of the members as well. I have a list of speakers, starting with Ms. Gladue, Mr. Caputo, Monsieur Fortin, Mr. Moore, Mr. Garrison, and then Madame Gladue, will start with you.
Thank you, Chair. You'll recall from when we were going through the testimony that I wasn't opposed to having a list. In fact, I think that a list of what constitutes coercive control will be very helpful in the training of police officers and justices. I don't really like this list compared to the list that England had, because I think there's some problems in this one. If you think about the limit on medications, I was thinking of some of my family members that are bipolar, for example, and sometimes they think they're feeling well and they don't want to take their medication, and their partner basically forces them to take their medication, otherwise they really escalate into a bad place. So, that's one of the things that's considered coercive control in this list. So I would rather not have the list in there. I thought that originally having a list would mean more convictions, but we heard testimony that out of all the ones in England, 6% of the cases that were brought forward saw prosecution, and out of the 700 that were prosecuted, only 3% saw conviction. So I'm not sure that this is going to actually fix the problem, and I think there might be a couple of things in the list that are problematic, so I prefer not.
Thank you, Ms. Gladue. I would like to receive a response from our guests, I guess, that are here to help us specifically to what Ms. Gladue has mentioned.
Thank you. Yes, it's important to remember that none of the conduct that's listed in that list can be considered prohibited conduct for the purposes of the offense unless it is considered in all the circumstances to reasonably be expected to cause the intimate partner to believe their physical or psychological safety is threatened. So that is the legal test. That conduct is illustrative of types of conduct that could meet that test, that we know has met that test in real lived experiences, but the test would need to be met before it could be considered prohibited conduct for the purposes of the offense.
Ms. Gladue, are you okay with that? Do you have another anything to add on that?
On to Mr. Caputo.
Mr. Caputo, please.
thank you as well to our subject matter experts here. And I appreciate what you said, that really, if I hope I don't paraphrase incorrectly, but what I took you to say is that the legal test requires the outcome, as in the intent to do this, or it's reasonable that this is going to follow, as in the wording in the act that a person would fear. Again, I'm paraphrasing. My concern, though, is obviously that's when we get to the point of conviction, right? At that point, you're before the judge or jury, as it may be, and when we're looking at things like controlling physical appearance or access to health services or medication, my concern is that perhaps we are muddying the waters about what this does entail. I mean, obviously, none of us want to see coercive behavior. None of us want to see any behavior that's isolating. So, like Ms. Gladue, I do have some issue with, especially on the medication end, or a person expressing spiritual beliefs. I mean, this is something that couples are often going to discuss. And at what threshold or at what point does that bleed into criminal behavior? That line, I understand the test that you've enunciated, but that line is less clear for me. So I'm not looking for an answer from the experts. I'm just intervening with some concerns.
Thank you, Mr. Caputo. I personally would like to know if you have anything that you can share with the committee and the public at large who is listening and who has a stake in this on that exact point.
As I said in relation to the other question, none of that conduct can be prohibited conduct, or can be considered coercive conduct for the purposes of this offense unless it meets that safety test. It has to be considered to be reasonably expected to cause the intimate partner to believe their physical or psychological safety is threatened. But in addition to that, we have to remember there is a mental element that also needs to be proven, which is either intent to cause the intimate partner to believe that their safety would be threatened, or being reckless as to whether that would ensue from their conduct. So there are a lot of protections built in to ensure that that list of conduct is truly just illustrative and based on the lived experiences of those who have gone through this horrific, or being subjected to this horrific crime, or soon-to-be crime, perhaps. It's up to you to decide that. But it's very carefully crafted to ensure that only the person who is holding the power in that relationship, only the person who has the power, not the vulnerable person, would be captured by it through both the intent element and the way that this third category of conduct is defined with respect to a legal test that has, by the way, a lot of appellate jurisprudence interpreting it, so we do know what it means, at least in the context of human trafficking, which is an overlapping type of crime. Thank you.
Thank you very much. Yes, Mr. Caputo, please. Yes.
Thank you. That's very helpful. So just so I'm really clear here, let's take sub 6 as an example. A person must cause their intimate partner to believe that their partner's safety is threatened, or they're reckless to the belief that their safety is threatened if they engage in conduct that controls the intimate partner's expression, thoughts, opinions, or religious or spiritual beliefs. So the connection there is that the person has to, that the victim in this case has to feel a threat of personal safety, a threat to their personal safety that the accused either intends or is reckless to based on how the person is expressing their spiritual beliefs. Do I have that right?
I think first you need to go to the legal test that's in the third category of conduct, which is whether or not the conduct could reasonably be expected to cause the intimate partner to believe their safety is threatened. So that's the first analysis that a court would need to struggle with. is the way in which that particular accused is seeking to control those forms of expression, could that reasonably be expected to cause the intimate partner to believe their safety is threatened? And then in addition to that, the intent element or the mental element would also require proof. Now that could be inferred from multiple examples of prohibited conduct. For example, if the accused engaged in violent conduct, sexually coercive conduct, and also some conduct from this third category, which is any conduct that could reasonably be expected to cause the intimate partner to believe their safety is threatened. And these are just examples of different ways that we've seen in the literature and the research that coercive controllers have sought to control their victims. But it has to be read in the context of the overall offense. And it has to be remembered that that legal test will require proof. And it's an objective one, so it's based on what a reasonable person would think in that particular context, which is a lot like Scotland, New South Wales, and Queensland. They also ask for that analysis.
Okay, thank you. I just, last follow-up, I apologize. This is because it's very helpful. You're being very clear here. So the first element that somebody has, that would have to be proven beyond a reasonable doubt is that objective. It's an objective, not modified objective. Is that correct? It's an objective?
Well, some may say that you're also supposed to consider in the circumstances, in all the circumstances of the offending, which does require an analysis of that particular context, and then the interpretive provision helps with that to tell the person who's looking at, the criminal justice practitioner who's looking at that situation, to look at the whole context of the offending to try to identify where a power imbalance is, where a position of vulnerability is.
So we may actually be looking at this in part through the victim's eyes objectively, and then there's a requirement of proof of intent or recklessness. Okay, I'm sorry it took me so long to get to that.
No, you are correct.
Okay,
yes.
Thank you.
Thank you, Mr. Caputo. Your questions are very helpful. Thank you for that. Monsieur Fortin, s'il vous plaît.
Merci. Merci.
Thank you, Madam Chair. And thank you to Ms. Livman, Ms. Wiltsey-Brown for being with us today. And before I put certain questions, I've got a general comment to make. I was quickly reading through G2, and it seems to make sense. It seems to make sense, I repeat. And I understand that it respects our agenda that we set, but we received that on Friday afternoon, this amendment G2. And I imagine I'm not the only one who was busy back in my riding, so I don't have time to bring together my team over the weekend and study this. Basically, we were rewriting the bill with G2. I'm not saying that it's not a good redraft, but it's problematic because we've heard from witnesses on the former bill, and on Friday afternoon we rewrite the text. On Monday morning we're meant to adopt it. It seems a bit quick off the mark in terms of procedure. I think it would have been advantageous to have worked with this new text as our basis, or at least have had one meeting to work on this text with witnesses. That was by way of introduction. My general comment. For all MPs, we have to have time to work on this. When we're just changing a phrase, a paragraph, a sentence, that's fine. But rewriting a bill on a Friday afternoon to vote on it on a Monday morning is kind of pushing it a bit. It's almost a lack of respect vis-à-vis the work of the committee. And of course, I'm showing full respect for my colleagues on the government side, who, of course, have the best intentions, but it does seem that we're moving a bit quickly on this. Having said that, is everything okay, Madam Chair? Can I continue? Yes, I do understand. I'm just checking the dates with our clerk, and he told me, well, I can see here that the amendments